gentlemen, my name is Bootwong, and today I'll be presenting to you about the contracts for international sales of goods, focusing on the United Nations Convention. In international business, when any dispute arises between parties, the most common dispute resolution is through arbitration. This is to avoid any damage on the working relationship shared between parties. However, in the case where the dispute falls out of the scope of arbitration, or when the arbitration agreements provides to be invalid, the process of litigation in court will take place. In the international contracts for sales of goods, the choice of law term or the governing law stipulates chosen national law that will apply in the case where any dispute arises. The conflict of choice of law in international contract for sales of goods can arise between negotiating parties when both parties nominated their own national law as the preferred choice of law. This can result in unsettlement of choice of law. For example, Party A is from Australia and Party B is from Thailand, and they both nominated that the national law will be used as the preferred choice of law. This can result in a very timely, costly, and unpredictable negotiations. In the next slides, I will be introducing the mechanism to minimize the conflict arises between the choice of law. The United Nations Convention on Contracts for International Sales of Goods, CISG, Vienna Convention. The CISG was first adopted in April 1980 by UNCITRAL. It is a harmonized legislation. It aims to provide a modern, uniform, and fair regime for the contracts of international sales of goods. So when does the CISG apply as the governing law of a contract for international sales of goods? According to the CISG Article 1, Section 1, Part A, firstly, when the chosen choice of law clause is one of the contracting states, or secondly, when one or both of the contracting parties are residents or are doing business in the contracting states. Thirdly, when both of the parties cannot agree to the choice of law. The third, neutral states apply. The CISG Article 1, Section 1, Part B, the principle of private international law or the conflict of law operates as such. The CISG can be the governing law of the contract even when neither of the parties operates their business in the contracting state or are residents in that country. So, what is the contracting states? Contracting states refers to the countries that adopted CISG. So to your left, it is a map of the CISG adoption. There are currently 89 countries that adopted CISG, including Australia. Let's have a look at the case in 2003. Playcorp Pty Ltd versus Teo Keigo Ltd. It is a case against damages and loss. Playcorp is a toy company based in Australia, while Teo is a toy company based in Japan. Teo supplied damages product to Playcorp. Playcorp then claimed that the product does not fit the description of goods provided in the contract. The claim was based on the CISG Article 35, Section 1, the Convention of Fitness for Purpose and Mercantile Quality. Teo then argued that the CISG does not apply to the case because Japan is not part of the contracting states. Just bear in mind that in this case, Japan has not adopted the CISG convention yet at the time. However, later on in 2009, Japan adopted the CISG. During the pleading, the choice of law was not stated. Playcorp then argued that according to the CISG Convention Article 1, Section 1, Part B, the principle of private of law operate that such CISG can be the governing law of the contract even when Japan is not part of the contracting states. The Victorian Court recognition and enforced that Playcorp is entitled for the damage and loss caused by Teo. To conclude, when does the CISG apply as the governing law of a contract for international sales of goods? It applies as the governing law when the contract stipulates that CISG is to govern the contract. Just bear in mind that even though parties do not agree to the application of the CISG could still govern the contract. On the other hand, to exclude the CISG out of the contract, Article 1, Section 1, Part B allows the contracting states to opt out, followed by the Article 95 Declaration. Thank you for listening. The next slide will be my reference list. This is my reference list.